I think that I was a junior lecturer at a law school in first Oxford, then London, and international law needed teaching, and there was nobody else who was teaching it. So I don't think I ever really made a decision to have a career in international law. Did you?
In my case, I'd gone through as an incredibly unhappy law student at the University of Melbourne in the 1970s and kept wanting to drop out and thinking this is absolutely awful. I just didn't enjoy the study of law at all. And then finally, in my final year of legal studies, I studied international law, and it was the first subject that I enjoyed. I really loved it, and I thought this is so interesting. What I loved about it was that the politics of law was so much to the surface. Like, you couldn't disguise the fact that law was essentially a very political institution and had political impact and effects. So I knew that I loved international law, and then I got involved in the Jessup Moot, and I really enjoyed that. And so I guess that's where I first really felt this is something that interests me. But I hadn't expected to end up as an academic. I really thought I'd go to the bar. That was what I was aiming to do. But after doing graduate study in the US, I became so enthralled by graduate study, and I was so inspired by, I think, the teachers I had in the United States, that I thought I would really love to become an academic. And it's also, if I'm honest, it's because my 2 years in legal practice that I've had, I was manifestly an incompetent practical lawyer. So I had to find something else to do.
I mean, yeah, maybe I was being a bit too dismissive. And equally, I was unhappy at law school and did not like black letter law. But in my final, it wasn't just international law in my final year, it was also Roman law, which again, I really enjoyed, comparative law. So it was that sort of range of subjects generally. And yeah, I think we both do share in common that going to the States for study, I actually went to teach originally. Complicated story I won't go into, but ended up at Yale for a year, and very much under the influence of Miles McDougall and Michael Reisman at that point, who were both completely inspirational and extraordinarily generous. And I think that was a real turning point for me as well. I think a real turning point, certainly for me in international law, was when we met and began collaborating.
Yeah.
I mean, I think that in terms of career in international law, that was a very clear turning point.
Yes, I think that certainly changed, I think, the type of research. And I think in those days, so this is rewinding a bit, I think academia, even international, as enjoyable as teaching international law was, in Australia at least, and I think more generally, it was very much a men's club. Like, it somehow attracted a certain type of cosmopolitan male figure. And I think the conference that we first met was such a typical conference. It was an Australian international legal conference where people grouped together to give papers.
And it was the Foreign Service, some academics, I think everybody was in suits. I mean, it was a very formal sort of type occasion.
Yes, a very sort of set piece one. And I think it was, when we first met, we became friends. I don't think at that stage we thought about feminism very much. In fact, we just kept up the friendship, and then it was having women's friendship at these very male dues. We would escape and go and have a coffee, or we called it, let's escape from this and get out. So it was very much having at least a social basis, and as you say, friendship within that. And that was really long before we started work on feminism. So we were just friends, and Christine at that stage was doing her PhD on third parties in international law. So, and she was also, I remember you were very well known for your work on soft law. You'd written that important article on soft law, and I was busily working on fascinating topics. I do think genuinely they're fascinating. Customary international law and recognition in international law. So we were both, we just had a friendship, and then each of us, Christine was at the University of Sydney, I was at the University of Melbourne, and each of us had then quite separately become involved in feminist legal theory and the effect of feminism within the academy, but we didn't imagine, it took us quite a long time to think that feminism had anything to say to international law. In fact, I think I remember saying to you perhaps at one point, oh, well, yes, our interest in feminism and law, that's very interesting, but of course it doesn't apply to international law at all, because international law, the main actor is the state, and there's no feminist angle on that at all. I remember that's really what we thought.
And then we, quite know one of our escapes from the Classic Men's Club conference, suddenly began saying, well, let's think about it, maybe there is. And I think
it really started in quite a funny way, because we were thinking with our dear colleague Shelley Wright, who was also at the University of Sydney. There was a call for papers for the Australian and International Law Conference that year, and we were sitting round with a glass of wine, it should be said, and we were saying,
let's give a paper,
and let's suggest feminist approaches to international law. We had no idea what we were going to say. We were pretty sure that the organisers would reject the paper, so we just said we'll put it in, and we expected a rejection.
We wrote an abstract or a napkin in the bar while we were there.
And then we put it in.
And then they said yes.
The organiser, who was our wonderful emeritus colleague, Professor Don Gregg, he's this sort of very open-minded sort of person.
Fairly maverick, actually.
He's a maverick. Yeah. He's a conventional international lawyer, but a maverick sort of.
Yeah.
And he said, "Sure, that sounds good." And then we said,
"What do we say?"
we had no idea. We were terrified. We said, "We've offered this paper and we've put in an abstract. We've got no idea what we're going to say." So we divided it up into 3, and we just said, "Okay, you've each got to come up with things." This was pre the internet, so we had to get on the phone. I remember, and we were speaking to each other. We were all in a panic, thinking, what on earth
are we going to
say? But we came up with something. I mean, what's striking is, and I think there's a lot of fascinating research now, is that we know so much more now about the engagement of women, really from the end of the 19th century, in international women's movements and these international congresses of women. And a number of historians now are really beginning to pay a lot of attention to the role of women's organisations. And the more that I've read about this, the more fascinated I've become about how extraordinarily we're organised, how these women, we often think of the women's movement beginning much later, but here were women using the international sphere, and sometimes the different feminist groups were having major arguments between each other during the time of the League of Nations, for example. There were fascinating debates that are still echoed today between some women's groups who wanted to argue, look, we have to protect the special nature of women, for example, through ILO conventions, and some women saying we want absolute equality straight down the line. Huge and sometimes very bitter debates.
And also about methodologies. I mean, we see it very clearly in the suffragette movement, between those who are militant and are prepared to use violent means, and those who reject any such form of violence. And I think you get that, perhaps not as extreme as in the context of the vote debate, but more generally. Very different views about methodology. But I think what's fascinating is not just how much we're now seeing about how many women were influential, but how completely it got lost. How it just vanished completely from the academia, from the discourse, from the archives. Well, no, it's there, but from the institutional assumptions about international law.
It's known, for example, I think this is now beginning to be quite well documented, that the International Congress of Women in The Hague in 1915, whose centenary was celebrated, of course, 3 years ago, how influential its resolutions were on the final peace plan. But this was completely unacknowledged, that these women took them to Woodrow Wilson and other world leaders with varying degrees of welcome. But this incredible contribution, which has been, if you look at the standard histories of the Paris Peace Conference and so on, it's been utterly pushed out. So, as I say, I think there are now some fantastic historians and others who are really working through the archives to uncover this material. But it's astonishing that it's, a century later that we're beginning to recover this lost history. And that goes to, you know, who is telling the story, what are the sources, and so on.
But it's also extraordinary just how much of the demands that those women were making in the League of Nations are still the demands that are being made today. So, I mean, two of the topics that were really being pushed by women in the League, or three of the topics that were really being pushed, was issues around trafficking, issues around the nationality of married women, and the whole issue that Hilary's already touched on around, is equality the appropriate framework to be pursuing, or should there be a more protective, seeing women as in need of particular special needs? And we still get that language, you know, in resolutions in the Security Council. We come back to the special needs of women, the vulnerability of women. These were debates, you know, that were going on way back in the 1920s and 1930s. And we still haven't resolved the proper approach to trafficking, for example.
I think that, as we were saying yesterday, I think, and I don't think it's due just to our scholarship at all, I think one of the things that we did, and in some ways when we look back, I think we think we didn't do it really adequately, but simply to draw attention to the fact that women and questions about women's lives had been pushed out of international law. In fact, after we gave the first version of the paper that then became the article in the American Journal of International Law that we described, I remember one of our senior, much beloved colleagues in Australia, a very eminent international lawyer, stood up and said, you know, what you're saying is, I'm paraphrasing here, is essentially really dangerous because you're talking about expanding international law so it will mean nothing. I remember him actually saying, if international law deals with violence against women, then you've more or less opened it up. There's nothing special about international law anymore. And that was the feeling. And I think now you wouldn't find somebody expressing things in that way. I think there has been an acceptance of the vocabulary, the fact that to say, asking the women question, what about women, people won't laugh you out of the room, people will pay some attention to it. We know that there are international instruments that use the term gender, such as the Statute of the International Criminal Court. So I think that there has been some success in having the vocabulary introduced. But, and this is just the major qualification, this is actually delivered in very little change. I think real change. And in a way, the institutions of international law have been remarkably successful, if you like, in absorbing an apparently radical vocabulary, but stripping it actually of all radical potential. I was just struck by the fact, just to give one example, and this is about the presence of women, but if you look, say, at the European Court of Human Rights, where in 2004 the Council of Europe adopts a directive saying the lists of judges, each country, you know, puts forward 3 names, must include 1 woman. And if you look at the history of that directive, you'd think, well, okay, let's hope, what does that actually meant for the court? And what we know is that at the moment of the 47 judges on the European Court, 14 are women. Now that's not a very good proportion, that's not even a third, it hasn't even got up to a third. So, and as I referred to yesterday, there's been, I think, this terrific study published in the European Journal of International Law by Céline where she really examines what's happened, the politics of that. And what you see is, first of all, you see all sorts of reactions. One is active resistance. Some countries, such as Malta, have simply refused on various occasions to put forward women. But you also see more subtle strategies where countries sometimes, as Stephanie says, either nominate women whose curriculum vitae are identical to men, so the exceptional women, or sometimes think, oh, we've got to put forward 1 woman on our list and put forward women who might be very learned but don't have a profile that's likely to have them elected as a judge. So you see all these different, both overt and sometimes more subtle strategies to subvert the value of this statement. And I think we see that type of strategies more generally, the acceptance of the vocabulary. Nobody's not accepted the directive, but have worked out various methods to get around its potential. And that's that's not in a big deal way, that's just simply about having women on lists for election. But we can see by the fact there are less than a third of women, that's no form of equality in an institution.
But what you've also left out there is that the European Court of Human Rights itself, in its first ever advisory opinion, essentially said yes, it was all right for Malta not to have women on the list, so that we don't even get the judicial support with respect to the application of a directive that had come down with respect to that. So it goes broader than I think just the political type response. I think as well that, and we touched again on this yesterday, that it's become in many ways just a sort of ticking box type response, so that how many women have we got on various bodies, and as Hilary's just said, in almost no case has it achieved equality. And just as a footnote, it drives me mad that 30% somehow seems to have become the goal of so-called equality. So we've already watered down what is the notion of equality. But very little consideration about why and what are the expectations, and are these appropriate expectations of putting women on bodies anyway. That representation has become more important than effective, meaningful participation in various ways. But I think, just going back as well, particularly when we published the article rather than the book, which was a decade later, I think there was an extraordinary confluence at that moment of activism, and activism in what we might call the international women's movement. In the CEDAW committee was really just beginning to find its feet, had a really effective and dynamic chair at that point in Elizabeth Ebbert, who was pushing the committee through its general recommendations into a whole new era of activism itself. We'd had the Nairobi conference, we were coming up to the Beijing conference. There were a whole, it was an extraordinary dynamic moment, I think, where the contributions of activists, those that were putting forward resolutions, documents, consultations, etc., at international fora, such as the Cairo conference, such as the Beijing conference, leading up to the negotiation of the Rome Statute in 1998. So on the one hand, there was the movement and a willingness from them to draw upon academic writing, which I think was in some ways quite new. And I think both of us were quite surprised when we would get requests from various campaigning bodies to use our work, or for us to go and help them draft ways in which matters might be presented.
But I think one real difference, and that we should celebrate, so you can see that we feel that it's been easy to absorb the vocabulary and the action has been so much more difficult. But I think looking back on this period of time, what I think has really changed is the generation that you represent, which I think is quite different. I think the fact that there are a number of younger scholars who've become interested in these issues and who, from a range of many different backgrounds, I think have written and spoken in very important and interesting ways on the ideas, have really pushed in much more, I often think, much more sophisticated and wonderful ways some of our early ideas. And sometimes, I'm not suggesting they're even building on them, they're sort of coming from completely different perspectives. That's what I find really exciting. And I think that the fact that there's even a group such as yours, I think that's a wonderful sign of action. I mean, that wasn't around, there was the American Society of International Law did have a women's interest group, and I think that was quite an important forum. But now what I've observed is that there's this younger generation with fantastic ideas and imagination, and I find that scholarship really energizing and exciting. So sometimes when we see that institutions have been slow to change and you think, oh, there are so many things that keep striking me about the way that institutions built on very patriarchal structures seem to just continue going. And I include universities in this. I think universities often are really unfriendly in that way. But despite all this, we have both wonderful generations of feminist activists and feminist scholars, and that's, I think, what really inspires me.
Yeah, there's a real difference, isn't there, between what you might call the sort of top-up international law, you know, the United Nations, the treaties, the International Law Commission, the International Court of Justice, all of that sort of heavyweight structure of international law, and the ferment and the excitement and the very sophisticated work that is underneath that. And I suppose the real challenge still is, how do we get the one into the other? Yeah. Friendship, I think, is far and away the most important part of it. I think people are always surprised that we've never actually been in the same institution, other than a very short visit here and there, that we've never actually had a long-term employment in the same institution. And we actually shifted continents fairly soon after the collaboration started. And this was all pre-internet and I think the fax had just begun, hadn't it? We
really are dinosaurs.
Yes, we really are. So how do we actually do it together?
I think we find that I think it's certainly because we enjoy working together, and we always try and have some collaboration on the go, even if it takes years for it to reach fruition, which it sometimes does. But I think that we've worked out ways we like. The most fun is, I think, when we're in the same room, which is very occasionally we can actually work. We literally work together at a computer. We're both sitting there throwing ideas and laughing, because the last time we worked together like that, one of my colleagues next door complained and said,
"Oh, really?
There's too much laughter." Said it was very, very noisy. Well, he's a very sweet person. No, I don't think it was really complaint. He said that was so much laughter out of your office, because we have it's just a lot of fun to write together. But I think usually we start with an idea of something we want to say, and we find that we have complementary styles. So I like to say that I'm good on the form and structure, but the content is Christine, who has this extraordinary knowledge and depth. She's always surprising me, shocking me by saying, "Haven't you read that decision from the Inter-American Court of Human Rights?" And I'm saying, "No, I haven't." But so I count on her, I think I always have, her extraordinary knowledge and ability to draw connections between ideas. And I think I am like an editor. I think I have an editorial eye, and I'm a frustrated architect perhaps, and I often will, and Christine is extremely patient with me as I move building blocks from one site to another.
No, you're not being anywhere near generous enough on yourself there. I think what's most exciting is that a bit like we just described the evening in the pub when the original article came out, a lot of the work we've done has come out of a casual conversation when we've suddenly said, hang on, there's an idea there, can it be developed, and we've got all over the place lots of half-started where we've had an idea and never been able to quite finish it up. But I do think that you're much better read than I am on the theory and precisely on the framing of where these ideas fit in and where they come. So it's complementarity, isn't it? But not in the ICC sense of complementarity. It's complementary skills, and And I think neither of us minds the other one saying, oh, come on, that really doesn't work, you've gone far too far, or, you know, that just doesn't fit there. You know, we're not, we don't get upset at each other's criticism, and we do criticise each other.
Yeah,
You know, quite a lot. I think that's important, that, you know, we can do so, and that it's taken always. It doesn't mean to say that we just accept the criticism and don't argue our point. We might do that, but we will come to a situation that we both think is to move forward on.
Yeah, I think it's not sort of an act of solidarity in the sense of we didn't do it deliberately as a statement, but I think it's been, and partly it's just because it's been full of pleasure, and I guess in a way we have watched each other's children grow up.
Our grandchildren.
And we're both up to grandchildren. So this is, you know, so I guess our lives have been intertwined in that sense. And
well, there was the very first great conference when Steph was, how old was she? When I was babysitting her while you gave the paper.
Yes, 6 weeks old. Yes,
and then handed her back to you while I went and did my bit. So, you know, that sort of collaboration.
Yeah, so that's been full of pleasure. But I think that, of course, we've both worked in quite different areas, and we've remained working in quite different ways as well. So I always regard writing with Christine as just an absolute pleasure, and then perhaps sometimes the other things I do as slightly more of a slog, getting those done. But anyway, it's been a terrific collaboration. But I think over the time, Christine has worked much more closely than I have with non-government organisations, and she's also been involved in different forms of practice. For example, as with the Istanbul Convention, actual treaty drafting, and you've been very involved, and I think the richness of that you've brought to our research, but she's, I think, had quite a different path than the sort of things that I've ended up doing.
You've done far more of the sort of constitutional, obviously far more on the internal Australian, but also, being an ad hoc judge, adjudication, again, it's been complementary skills, so we can both bring from the practice that we've done into the writing.
I think the collaboration and the excitement of ideas, I can remember, I think some of the times that were wonderful have been at conferences. I can think of a number of conferences where perhaps one's focusing on feminism and international law, which have just been so exciting, where different groups of scholars, different generations have come together. I can recall a number of those which have been...
Right back to Dorinda's first one in Washington.
Yes.
Yeah.
Dorinda Dallmeyer from the University of Georgia organised a conference that was very exciting in the early 1990s. I think that's wonderful, and that's continued with Christine's centre that she started at the LSE. That's also been a place and a space for really interesting discussions. So I think that's been some of the most exciting and interesting things. And then, of course, there have also been times when I think perhaps we've also got a whole chest of war stories about problems we've had at perhaps more mainstream conferences, and we perhaps shouldn't relate those here. But I think one of the other pleasures is sometimes us regrouping after an extraordinary event and saying, could you believe that? Did that really happen? And having the solidarity of support in just really being able to talk through perhaps a not so positive experience where with a dear colleague, and the fact that you're sharing it is I think is there. I was once told there was an Italian expression, mal comune mezzo gioia.
Mezzo gaudio.
Mezzo gaudio, thank you. And I think this expression, I think, applies. Well, it means when there's a common problem, you can actually find joy in that. And I guess we've encountered that many times.
If you just think sort of professional high moments, the moment we got the Istanbul Convention through, that was a real high spot. and there had been so many fights during the negotiation. Something like that was a very special moment.